Hello and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. A lot of people have been reading in the news that Justin Bourque was successful in going to the Court of Appeal to have his sentence reduced for multiple murders. And different media outlets have covered this in different ways, some very well, others less well. And so I thought I'd go through this case just to clear things up because I've been getting a lot of questions. There's also a side to this story that none of the media outlets that I looked at had covered, and I want to talk about, which is that really this is partially a story of a Crown prosecutor upholding the finest traditions of that office. So I want to commend that Crown prosecutor for their conduct on this file and explain that to you guys as well. So this is, as mentioned, the case of Justin Christian Bourque and His Majesty the King. Now, we're going to start off with the introduction paragraph because some of my viewers may not be familiar with this case, and it's good to know what we're talking about here. So they note, the loss of police officers at the hands of a murdering gunman is a senseless tragedy resulting in the untimely passing of people who put their lives on the line to serve and protect their community. It leaves families, friends, and colleagues, and indeed the community as a whole, in long-lasting, profound grief. Such a tragedy occurred on June 4th, 2014 in Moncton when Justin Christian Bourque murdered Royal Canadian Mounted Police officers Douglas Larch, Dave Ross, and Fabrice Gavaldin. I hope I'm pronouncing that right. In the same incident, he shot and wounded two other officers, Darlene Gauguin and Eric Dubois. I hope I'm pronouncing that right. So on August 8th, 2014, Mr. Bourque pled guilty to 3 counts of first-degree murder and 2 counts of attempted murder, and on October 31st, 2014, the then Chief Justice of the Court of Queen's Bench sentenced him to life imprisonment on each of these counts. The horrific details of the offenses, the impact on the victims and the community, and the circumstances of the offender are all detailed in the sentencing decision reported at, and they give the citation. So they note, the court goes on here to note, the sentence for first-degree murder is prescribed by Section 235 sub 1 of the Criminal Code as being imprisonment for life. That's the minimum penalty, is life in prison. Of course, imprisonment for life does not necessarily mean living out one's life in a penal institution, since our laws provide for the possibility of parole. In cases of first-degree murder, a period of parole ineligibility is set at 25 years. At the time Mr. Bourque committed these heinous and despicable crimes, in the case of a person who was convicted of murder and who had already been convicted of one or more other murders, Section 745.51 sub 1 allowed a sentencing judge to weigh certain factors and decide whether the periods of parole ineligibility should be served consecutively. Now, what it means to be served consecutively is one after the other, whereas otherwise they would all be served at the same time. The difference really is, if you have 25 and it's served consecutively with another, it's 25 plus 25 equals 50. Or if they're served concurrently, it's 25 and 25 equals 25. So this is going to be the big issue in this case because there's another decision which I covered in another video, and so you can check that out. I'll try to remember to link it up there. But that case threw that out. So we'll see how the impact of that case applies here. That's the case of Bissonnette, who is another mass murdering jackass. In Mr. Bourque's case, the sentencing judge determined the periods of parole ineligibility for the 3 murders should be served consecutively, making the total aggregate sentence one of life imprisonment without eligibility for parole for 75 years. That is, not until Mr. Bourque reached the age of 99. Now, prison is hard living, and it's not that common that people in prison live to the age of 99. So functionally, the chances, functionally that's just until he dies. Mr. Bourque did not appeal the sentence imposed on him within the 30 days prescribed in the rule of court. Now, the rules of court put limits on sentence appeals and really any kind of appeal because we want decisions to have a bit of finality, right? You don't want somebody to come back in 30 years to say, oh, I was improperly convicted, absent some really strong evidence. There are circumstances where those things can be reopened, but it's a bit of a further process. You don't just want to have that sort of as it goes. All right, now we'll skip ahead a little bit more. They're talking about the Bissonnette decision, which I did cover in a previous video, but just describing what happens on that one. In the final analysis, not only did the court declare Section 745.51 of the Criminal Code to be invalid, but it also struck down the provision retroactively to the date of its enactment. So it said not only is it invalid today as of the day it was heard in court, but in fact that it was never valid at all, and that, that's a big deal. So the Supreme Court's decision in Bissonnette makes the sentence imposed on Mr. Bourque one that is neither permitted by law nor constitutional. The court stated that any first-degree murderer, such as Mr. Bourque, regarding whom periods of parole ineligibility were ordered to be served consecutively, that is, 50 years or more, must be able to apply for a remedy even if they are no longer in the judicial system, and he was no longer in the judicial system because his appeal period had ended, right? So relying on Bissonnette, Mr. Bourque applied for an extension of time to file a notice of appeal. And this is exactly what the Supreme Court expected people would do. So they say, in the normal course, his application likely would not have been granted, as he did not meet the established criteria for such relief, and they cite a case for that. However, to give effect to the Supreme Court's directive that an offender such as Mr. Bourque should be able to apply for a remedy, a consent order was signed extending the time for him to file a notice of appeal and granting him leave to appeal the parole ineligibility portions of his sentence. So that is the Crown Prosecutor saying, listen, I've read the decision in Bissonnette. It says that, this should apply for everybody, that it should be available for other people. And because of that, I don't think that they want, they're not trying to help out Mr. Bourque here. They don't have any, I doubt this prosecutor has any sympathy for Mr. Bourque or fondness for him or anything like that. But this Crown Prosecutor clearly has fondness for the rule of law and for the, the traditions of carrying out their duties to uphold the law and to give effect to it. So they could have been obstructionist here, and I think that they would have lost if they'd said, no, we're opposed to the late filing. Instead, they said, we will consent to the late filing because they're doing a really good job at being, at serving, the law and the principles of it. So I'm commending the Crown Prosecutor for that. In his appeal, Mr. Bourque seeks but one remedy. That is to have his period of parole ineligibility reduced to 25 years, consistent with the law as set out in Bissonnette. Mr. Bourque's counsel and counsel for the Attorney General have asked that the appeal be determined based on written arguments only. We agreed. So both sides said, you know what, we can just send in, we're not going to have to do oral arguments, assuming the court agrees, because this one isn't a fight. This one's actually an agreement between both of them. Mr. Bourque's argument in support of his appeal is simple. The Supreme Court struck down that section retroactively. As a result, Mr. Bourque should be sentenced to concurrent terms of imprisonment for life with no possibility of parole for 25 years. In reply, counsel for the Attorney General acknowledges the binding effect of Bissonnette and agrees that the appeal must be allowed, and the sentence varied to provide for a period of parole ineligibility of 25 years. So, again, this is a place where I'm going to say props to the Crown Prosecutor on this one, because they said, yes, this appeal is being properly brought because that's what the law says. And again, I don't think that they're like, hey, we want to help out Mr. Bourque, but they recognize that this is what their obligations are. So there's not been a whole lot of coverage of that and how the conduct here of the Crown Prosecutor is exactly what we'd want to see, because they could have decided, we're going to put up a fight for this. We're going to, we're going to drag him through this. We're going to whatever. But instead they're saying, this is just how the law is. Do the law thing, court. Good on them. Both lawyers are correct. Bissonnette is binding on us. And so what they mean here is some court cases are binding on other courts and some court cases are merely persuasive. And so the difference is that if a court is bound by a decision, then they really don't have any choice but to follow it, assuming that case applies. Whereas if a case is merely persuasive, then the court can say, okay, yeah, we have considered this case, but we're going a different direction. And in this case, because Bissonnette is a Supreme Court decision, it is binding on this lower court. So we are duty bound to vary the sentences such that the period of parole ineligibility be concurrent terms of 25 years. In all other respects, the sentences imposed remain unchanged. So note, Bourque is still serving life in prison. It's just the question is, when is his period of parole ineligibility? Now, a lot of media organizations reported this as saying he's going to be able to get parole, and they'll specify the date. That's not really true. Let's keep going here because the court's going to have some additional comments here. They note, as explained in Bissonnette, in the current state of the law, Mr. Bourque will be eligible for parole, but eligibility does not mean he has a right to parole. As the Chief Justice observed, experience has shown that the parole board generally proceeds with care and caution before making a decision as important as releasing multiple murderers back into society. The protection of the public is the paramount consideration in the board's decision-making process, but the board also takes into account other factors such as the gravity of the offense and its impact on victims. It perhaps provides a measure of solace to know that compelling evidence of rehabilitation will be demanded before the perpetrators of such crimes will be released on parole. That's probably an understatement. And so they note, for these reasons, the appeal is allowed and the sentences are varied as set out above. Now, lots of people have said, well, what does this mean? When is he getting out? And I can tell you that it's a virtual certainty that when he's getting out is never. The chances that he gets out are very, very poor. And even if he lives to be 150, I would be surprised to see him ever get released. I would be surprised to see him have any hope of getting released, period, full stop. So that's just something to keep in mind on this. This is merely the point at which he can apply, but you can expect that the response, the parole board's going to have a very difficult time, with that application, mostly because it's very hard to figure out how to write out laughter. They're gonna, when he's going to apply, they're probably going to write out a very lengthy thing that says, here's why you're completely out to lunch. This is not happening for you. And that applies pretty much no matter what he does. Because the crimes involved are so heinous and so have so grabbed the public attention, what I would expect to see is that there would be, they'd say, oh, well, you made these steps towards rehabilitation. Those are really positive steps. You've done all of this good work. And ultimately, it's not good enough. He could have, signed letters of recommendation from, Jesus and all of the other sort of major figures in various religions around the world, attesting to his good character, and they'd still be like, nah, not happening. I can't see him getting out during his lifespan, with one exception, which is if age at some point sufficiently incapacitates him such that he's basically unable to move or whatever else. Sometimes people are released on parole so that they can basically die in the parking lot or, at a medical facility outside of the prison. But that's not really, hey, we're going to release this guy into the public. It's usually, hey, this guy is so sick and so immobile and so unable to do anything that really it doesn't matter where you keep them, right? It's so that's pretty much what I predict for Mr. Bourque's future. As much as they have reduced this and as much as it was proper to reduce it in light of that Supreme Court decision, don't expect to be seeing this guy out anytime soon. I don't even know if he'll consider it to be productive to apply for parole when he's up for it. There's just the chances of being granted parole with more than one murder are shockingly poor. They're just so not going to happen. Anyway, I thought I'd explain this one, go through it. Really, the angle I kind of wanted to talk about that no one else, I might not have actually covered this one, but for the fact that I wanted to specifically commend this Crown prosecutor. I can't imagine that they liked doing this. Like, I can't imagine that they thought that this was a great thing to put their name on, that they thought that the media would treat them well over this one. And some media organizations have suggested stuff that I think is wildly improper. I'm not trying to do a name and shame here, but there was one article I read that basically was like, why is the Crown agreeing to this? Well, because it's the right thing to do in keeping with his ethical obligations. That's why. So I really wanted to mention that and just, yeah. So thank you guys for watching. Please like this video, share it with your friends, subscribe if you'd like to see more content. I also want to thank my Patreon supporters at the $50 level, CCFR, David Michaud, Canada's National Firearms Association, and the Canadian Shooting Sports Association. At the $30 level, Sights and Arms Limited and Jane Babe and Luxor. And at the $20 level, Lindsay Metcalf, Kyle Fox, Haywire, Gerald to the Bailey, Cameron Johnson, Andrew Elsich, and Vicky. Thank you as well to my $10 supporters who will be in the crawl immediately following. Thank you for watching. I hope this has armed you with knowledge. See you next time. And next time, I'm probably going to be covering a bit of a funny case where a different Crown prosecutor tried to pull a fast one, and it didn't work out for them. So I guess we can have, this one is, we've got a Crown prosecutor who's really doing their job well. And the next one is someone who's not doing it so well. So stay tuned. Cheers.